Okay, so I think we'll start, and thank you, Charles, for looking after the door for me. Very important role for which you need lots of training. A very warm welcome to everyone who's joined us today in this, our 11th CIG Services Masterclass, and greetings to those of you who are joining at times well outside the normal working day. Thank you for making the time. I'm Amanda Bucklow, I'm a commercial mediator, and as part of CIG Services, I specialise in accelerated dispute resolution and project negotiation and mediation, and I'm your host for this morning's masterclass. Today's masterclass is scheduled to last for 60 minutes. After the main conversation, our speaker will answer questions for approximately 20 minutes, supported by my colleagues. If you do have a question for our guest, please put it into the chat, and I'll gather those together for the question session after the presentation. And thank you to those who sent questions to me ahead of the event. Please let us know in the chat if you don't want your name included in any attendance list. And I have a couple of polls that I would like you to participate in. One is about how you access today, and the other is, of course, some kind of feedback on the presentation and our session. The session is being recorded and the video will be available on the website together with the presentation. You will receive an email once those are available. CIG Services is a group of innovative and experienced construction professionals from many disciplines. We rapidly evaluate construction, operational and financial performance to meet project or investment objectives, or indeed to support turnaround. And over the last 2 years, CIG Services has offered insights and proposed actions to support the construction industry. In May, we initiated and were signatories to a letter published in the Times, and our theme of improved governance in the industry is further explored in today's masterclass and from the point of view of the Building Safety Bill 2021 and associated regulations, which are still very much in draft. The bill itself runs to some 216 pages. Professor Rudi Klein is our speaker, and welcome, Rudi. I'm sure that you are known to many attending today, and I would still like to say a few words by way of introduction for those who may not. Professor Rudi Klein has pleased many and irked others with his persistence and determination to improve the complex contractual relationships and trading conditions of the supply chain. Rudi's principal focus is to level the payment landscape for firms of all sizes and to realise a more balanced share of risk and reward in the interests of all stakeholders to improve the long-term health of the industry. With his legal background and a rich history of thought leadership, notably as CEO at the Specialist Engineering Contractors Group until the end of last year, Rudi brings a unique perspective on the implications for the industry, including the supply chain, as they organise and prepare for compliance with the new Building Safety Bill 2021. For such a huge topic, Rudi has set himself the daunting task of extracting a framework to work with. And in identifying the implications and challenges, he invites you to see the springboards for opportunities in your areas of interest and to look and absorb the areas in which you might need to pay attention, do extra research, and really get clear about what it is that you will need to do in order to take this bill forward. Rudi, welcome.
Thank you, Amanda. That was a wonderful introduction, one of the best I've ever had in my life.
Thank you.
Thank you for that. Okay, well, my interest in this subject was initially kicked off when I was asked by an MP a while back now to consider whether we could do something on payment in the context of this bill, because as Amanda rightly says that's been my main interest, which has been payment, contracts, and procurement and risk. And I then drafted an amendment to the bill, which is yet to be heard. The bill is in committee stage at the moment. And the bill reflects a point that was made by Dame Judith Hackett, who was asked by the government to carry out an inquiry into building safety. And in her report, a final report, she said that part of the problem with building safety is the fact that poor payment practices, retentions and such like actually cause defects. They cause subcontractors to substitute poor materials. And she threw into that equation lowest price procurement as well. So what I did with her and with Parliamentary Council was to draw up an amendment which asks the government to carry out an inquiry within 12 months of the bill becoming law into the impact of poor payment practices, lowest price procurement on building safety. We had a very good example of poor payment practices affecting building safety in the report that was done following the collapse of brickwork at a school in Edinburgh in January 2016. 9 tons of brickwork collapsed into a school playground. And it was lucky that the children were still on holiday. Otherwise, that could have been a very, very awful tragedy. And the Professor John Cole, who reported following inquiry into that collapse, referred to the payment arrangements, which focused on the quantity of bricks you're able to put up in a day, rather than on the quality of the brickwork. Because what happened was that there were ties missing from a lot of the brickwork. There was also, in fact, fire safety issues also found in that inquiry too. So although Grenfell has been provided the immediate background to this building safety bill, there have been issues around building safety going back now a fair while. As far as this bill is concerned, it was introduced on the 5th of July this year. It's due to receive the royal assent next year, round about April time, but could be later depending on progress through both houses of Parliament. As I say, it's still just in committee stage at the moment. The regulations, the whole building safety framework is likely to be in place probably within a space of 2 years following the bill receiving royal assent next year. So the whole edifice, and Amanda's absolutely right, this is an edifice of control, an edifice of a regime about building safety. And of course, it has been quite a challenging task, as Amanda made clear there, to try and gather together all the material that's around, and I will just cover some of that in a minute. But to take bringing all this material together, and all I'm trying to do for you in the session today is to try and highlight what you should be looking at, and then if you want to obviously go further, then that is for you. But that's the aim of today. Now, I should say that as far as the bill is concerned, the long title of the bill is this, and I'll read it out because I think it's important that it is understood. A bill, and I quote, "A bill to make provision about the safety of people in or about buildings and the standard of buildings and the standard of buildings to amend the Architects Act 1997, these are the additional things, and to amend provisions about complaints made to a housing ombudsman." So it's mainly about safety, about standards, obviously, which are clearly interconnected. The point about the Architects Act of 1997 is that will be amended so that the Architects Registration Board will impose or have to impose ongoing monitoring of competence amongst architects. The point about the housing ombudsman, in fact, there will be actually a new housing ombudsman, a new homes ombudsman that will involve the drafting of a code of practice that will be administered by the ombudsman in relation to complaints about new housing. So anyway, I'm going now to look at the key resources that you might need to look at. We can kick off. I'm not intending to go through these in any detail. I mentioned Dame Judith Hackett's report. There were two reports actually done by her. One in December 2017, interim report. This was basically to get her going following the Grenfell Tower tragedy, to get her moving on what was going wrong and what needed to be addressed. And then we had her final report in May 2018. There was also a draft building safety bill that was published last year that went through a pre-legislative scrutiny by the Housing Community and Local Government Committee. And they reported back in November 2020. There was then the building safety bill, as I said, introduced in July. I should add really to that list, for those who are interested, there was a new Fire Safety Act that received the royal consent in April this year. That will provide yet for more regulation about fire safety. But what it does do is increase enforcement action, particularly in regard to failure to remediate cladding using aluminium composite material. And so that's another bit of legislation to add to the jigsaw. So then, of course, on top of this primary legislation, we have myriad regulations. As Amanda mentioned, many are in draft form. One that did come out this year was the higher risk buildings description and supplementary provisions regulations. It's a boring title, but what it does is fairly significant because it actually includes hospitals now and care homes. So we don't talk about high risk residential buildings. We talk about high risk buildings now, given that hospitals and care homes are included. I say hospitals and care homes actually have to qualify as high buildings, and I'll come back to what I mean by that in a minute. And then on top of that, there are guidance fact sheets. The government's published some fact sheets. It's useful to actually look those up. Also the Health and Safety Executive has published what I call the safety case principles. These are principles that will have to be used by people now in charge of safety and higher risk buildings. They're going to be quite important, particularly for the industry. I'll come back to those in my talk. One thing I should mention is that just to add to that list, but something perhaps I shouldn't say because it's still highly secret, but I will, provided you keep it secret, even though this is recorded. There is due to be released by the government over the next few weeks a fairly lengthy guide for the regulator on procurement issues, and that's going to be if you are interested in procurement around building safety, this document, when it does emerge, will be a very useful one to read, because it will be talking about the need for greater collaboration, alliancing, integration of procurement, of input. So one to watch out for. I can't give you any more details on the content. I'm not allowed to. Apparently it's a secret. But well, it wasn't up to there anyway. But anyway, Building a Safer Future, because the independent review of building safety by Dame Judith Hackett was the document that led to the bill itself, the drafting of the bill, and the bill takes on board pretty much what Dame Judith said, apart from the bit I mentioned earlier about payments, which I think, in fact, should have been incorporated in the bill. So as we move to then the next element of my talk, what she highlighted was the major fault lines in the procurement and delivery of construction. I have to say to you, I'm not surprised by these findings because, I mean, if I'm frank, I think these have been repeated in many, many different reports before. And in the summer of 2018, I read about 15 or 16 reports published on construction that went back to October 2016, the Mark Farmer report, Modernise or Die, that the government procured. All these reports that I read, and I distilled the key things, there is nothing in, I have to say, in Dame Judith's findings that I certainly haven't seen before. And I reckon a lot of you listening in and watching in will probably say the same. I don't really need to go through this other than the fact just to highlight the fact that the difficulty we have is that we simply don't know where risk lies, is the truth. You know, we talk about the problems with insurance. I know, you know, that to my friend Graham DeRoy is on the call. As Graham will well know as an insurance expert, we've never really been able to tie down exactly where risk lies. Who owns risk? Because usually, of course, everybody thinks, even, I mean, when CDM first came in, the Construction Design and Management Regulations about building safety in construction, everybody thought that you could actually transfer statutory responsibility and ditch statutory responsibility. I pass it down the supply chain. But in that list in front of you there, competence is something that I want to come back to. Just on product testing, labeling and marketing, I just want to mention there, and I think it's worth mentioning this because I'm not going to really come back to that, but for the moment, I mean, obviously we all know about the issues that came out of coming out of the current inquiry into Grenfell about the lack of testing of products, about the mislabeling of products, about the suitability for purpose. Now, the likelihood is that out of this, there could well be a regulator for products to ensure that products are properly tested and labelled and so on. And the bill does give the government power to introduce yet more regulations that will deal with the construction products. So I just thought I would just mention that. But the rest of it, again, something that we're not unfamiliar with. And I've just put up there some what I consider to be some of Dame Judith's choice quotes. Basically, the system's failed. It's not about specification, just a cladding system. It runs far, far deeper. I mean, this is quite an indictment of the industry. The industry has not reflected and learnt for itself, nor looked to other sectors. It's a massive indictment of the industry. And the industry has got to do a massive amount more to give better assurance about building safety and building standards. And it's a good message to get across. Again, the key question, which we'll probably look at the end, is what is the likely impact of all of this? Right, so I've just got a couple more there. The payment one I've put in there because that's the one that's behind the amendment that we've put down. If you want to see the amendments, by the way, that are currently in committee, if you just go to just Google Building Safety Bill and you'll come up with the various bill documents, and you'll just click on that, and that will give you all the amendments that are currently being put down. One thing I should just highlight was the first bit there. The heart of this report is a new regulated framework, and I've highlighted this bit here, that will drive real culture change and the right behaviours. This is the theme that's coming through now, all this legislation, all these regulations, culture change, the right behaviours. That's the big thing to fix on here. Are we going to see, after all these years, the right behaviours emerging? We'll have to wait, I suspect. So she, Dame Judith, then identified what needs to be done. These are the key recommendations: a new regulatory framework in place with focus on getting design and construction safety right for the buildings coming within scope. The initial focus will be on multi-occupancy, higher risk buildings. I have to say, over the longer term, that could carry across to most building work. She recommended an instant reporting system for duty holders. I'll come to duty holders in a minute. But as we move on, she did also mention that there needs to be this duty holder regime that has clear roles and responsibilities earmarked and set out. And that's been the problem. As I said earlier, we don't really know where responsibility lies, risk lies, and so on. There will be a system of gateways introduced. This is for higher risk buildings. And the other thing I'll be coming back to, this golden thread of information, and this whole system of collecting, recording information. We've got to change our way that we address this. Those of you who remember years ago, when in about 2011, the government said from 2016, we will mandate the use of building information modeling. And those of you who are experts in building information modeling, let me say I'm not. But those of you who are will know that really is key to building information modeling is having this reservoir of data that we're all inputting and sharing between us on projects, just common data environment, if you want to use the jargon. But the problem is nobody's sharing this. This has been the problem with building information. People are reluctant to share design information and so on. Whether this will change, we will have to see, but the energy in this legislation is about securing that type of change. Then, of course, we come back to competence, and that needs to be driven by some overarching body. Looking at the bill now, and coming to the bill, and looking at the provisions of the bill, we will have to now get used to something called this new building safety regulator, who will report to the Secretary of State. Now, I have to say, the regulator, those of you who know a bit about pensions, I'm quite heavily involved in pensions. I sit on a couple, as a trustee, on a couple of pension schemes. The pensions regulator is an organization. There's no individual as such as the pensions regulator. It's an organization. So this new regulator will be an organization probably employing about 250 to 450 people. And of course, the much of the success of this legislation will depend upon the resourcing available to the regulator. If that resourcing is poor, this bill is not going to make any difference. It's got to be properly resourced if it's going to make a difference. At the moment, there's like a shadow regulator in place that's headed by the Chief Inspector of Construction at the HSE, and of course, the regulator will sit in the Health and Safety Executive. The regime will primarily be applicable to high-rise buildings. These are buildings at least 18 meters in height, or at least 7 stories, with at least 2 residential units. And as I said earlier, hospitals and care homes, again, of the same size, are included. Going to back to the building safety bill, I think.
Sorry.
That's all right, no problem. We've got, I'll be dealing with competency and the new competency requirements. There'll be a gateway scheme that we'll come to, and then there will be finally a new regime for overseeing and managing safety in higher risk buildings. So we come to the regulator now, and what is the regulator going to be all about? Well, the hope and the expectation is that the regulator will be fully operational within about 12 months, 12 to 18 months of this bill getting the royal assent. And in fact, the new regulator, there's 4 functions that we need to be mindful of. The first is that the regulator now will take over as the building control authority for high risk buildings. And in respect of that, will also develop a totally new regime for the safety of high-risk buildings at the stage of occupation. That will all change. Once these buildings become occupied, then a new statutory regime for how they're going to be managed from the safety point of view will then set in. But everybody thinks that the regulator is actually going to be about, just about higher risk buildings. Actually, the regulator is going to have quite an important function in the way that it will have oversight of standards of building control standards, managing risk right across the board. And in fact, the government, the Secretary of State will be going to the regulator for advice. I should add also, before I go into this slide, is that the regulator will have to draw up a strategic plan as to how it intends to go about its business and its statutory responsibilities. That strategic plan has got to be approved by the government, by the Secretary of State. So competence is the big theme in this legislation. The regulator will want to support industry efforts to improve competence. There will be a competence committee to support it. I'll mention this in a second. There will be, in the longer run, a regulatory framework for industry competence, possibly covering designers, covering constructors. He will also have a much more interventionist approach within building control. He will keep a register of building control professionals, or building control approvers, as they now will be called. There will be also a system of building control inspectors, will provide advice to local authorities. So we've got building control inspectors, building control approvers. These will have to be registered, and the regulator will register these people. And then there will be quite specific enforcement powers, primarily dealing with buildings in occupation, high-rise buildings in occupation, and dealing with the people responsible for managing safety in high-risk buildings. So as we move to then the next bit of the building regulator functions, the regulator will have support from three committees. The Building Advisory Committee, that will support the regulator on its building control functions. This replaces an existing committee which was set up, I think, under the Building Act of 1984, which is the Building Regulations Advisory Committee, called BRAC, I think, for short. There'll be a committee on industry competence. I have to say there has been ongoing work on industry competence following, in fact, the Grenfell disaster, and that work will no doubt morph into this committee. And finally, there'll be a residence panel that will allow residents of higher risk buildings to provide input to the work of the regulator. So that's the regulator, which then takes me into the second tranche of this legislation, which is this new duty holder setup. Again, if you love reading regulations, the key ones here are the appointment of persons, industry competence, and duty holders, England regulations. I have to say, I mentioned England there. Building regulation is a devolved matter. So those Scots, Welsh, Irish looking into this, watching this, Scotland is, of course, has its own devolved approach to building regulation. Wales the same for the last 10 years or so, but Wales has asked the UK government to legislate for Wales on this new duty holder regime. But I think the Welsh government intended to amplify that regime by its own regulations. That's as I understand it at the moment. And Northern Ireland apparently are also doing some work on developing a building safety program. But the key thing to remember, if you are from the devolved regions, that they have their own approach, will have their own approaches to this issue of building safety. The key duty holders that have to be appointed by the client will be the principal designer and the principal contractor, but there will be other duty holders, designers, and contractors. They have to be appointed before construction begins. For those of you, by the way, who are looking at these duties, who are familiar with the construction design and management regulations, the CDM regulations of 2015, you will say to yourself, well, I know something about this. Surely this is the same. What they're doing is just repeating what's in the CDM regulations. And to some extent, that is correct, but there will be some differences. And one of these differences will be in relation to behaviors, which I'll come back to in a minute. But as far as the principal designer is concerned, the principal contractor is concerned, the client can use the PD and the PC, as it were, appointed for the purpose of the CDM regulations as a duty holder under the building safety legislation. So it makes it a bit confusing. In fact, it is confusing, but I'm sure it'll be ironed out in the wash. But as I said earlier, there's likely to be more stringent duties on principal designers and principal contractors under this new regime. Basically, all it amounts to, they've got to take all reasonable steps to make sure that they plan, manage, and monitor their work. One thing I should mention before I just tackle these competency requirements, just on the client. One of the things the client's got to do in managing the project is got to actually provide designers and contractors with sufficient opportunity to be able to work together on how best to design out building safety risk and also how best to construct without bringing about safety risk. And whether that's going to mean the need for early appointment of the supply chain, the key elements of the supply chain, M&E, steel, lifts, and so on, that remains to be seen. But I would have thought for this to happen, you've got to appoint people earlier. So we'll just see how where this takes us. So as we come to competency, again, these new, or I say these regulations are in draft at the moment. Their content is going to be dependent ultimately on what happens to this bill as it proceeds through Parliament. So there is a requirement for competency. It's the same as the CDM regulations, but look at the second bullet there, because this is what I want to highlight. Each duty holder as an individual, of course, they can be organizations as well, as an individual must possess skills, knowledge, and experience. Skills, knowledge, experience. This is what we already see in the CDM regulations, which are about safety in relation to specific projects. But then it comes in with behaviors. And what's interesting, in these draft regulations, it does actually define behaviors. And those behaviors will include refusing to carry out non-compliant work. It will also include refusing to work beyond your skills and knowledge and experience. So in other words, everybody responsible for appointing somebody else who's going to be a duty holder has got to check on their behaviors. Now, this is something rather new. And got to ask these questions. Will you refuse to do non-compliant work? Will you whistleblow? Will you stop work if it's beyond your skills, knowledge, etc.? That'll be an interesting process. So whether that will be done rigorously enough, robustly enough, remains to be seen. But an interesting development. Duty holders, of course, can be organizations. I have to say, if they're organizations, there's got to be an individual appointed in those organizations who will, in effect, have the responsibilities of an individual duty holder. And I have to say, just to perhaps add, next year, as I understand it, the British Standards Institution will be introducing standards of competency for professional designers and principal contractors, and that might be of interest to insurers who are any insurers looking at this. So that they should be out next year. Also, with higher risk buildings, there's likely to be a requirement but the client will have to sign a declaration that they have assessed and are content with the competence of the principal designer and the principal contractor. We don't know yet. Regulations on these gateways are due to come out in the course of the next few weeks. So coming on to the gateways, these gateway systems are there in place, or will be in place, for work being designed and construction being carried out for higher risk buildings. The new three-way gateway system will be basically a structured approach about how you approach design and construction. It will basically have stop-start bits in it, and the gateways will be about how you've dealt with risk, providing documents showing how you address risk, your risk assessment, for example. Gateway 1 has already actually been implemented by amendments to planning legislation. So now developers will have to provide fire statements to planning authorities, which identify what they've done to address fire safety matters. That now has to be done anyway. Gateway 2, then again, just remind you, high-risk buildings here, the regulator, Gateway 2, has got to be satisfied that all the design construction work will comply with building regulations. So documentations, plans need to be provided at that point to the regulator. If it's not satisfied, the regulator can basically say, sorry, you'll have to wait until you need to provide me with more material. I need to see what more you're planning, so I can actually then allow you to go on to Gateway 3, with Gateway 3, of course, being the final bit of the jigsaw where all the documents relevant to the completion of the project. And this is where I think the golden thread comes in, particularly where all documents, records relating to the work have been collated and put together, preferably in a digital format. I have to say that one of the things you'll probably notice from all of this and from what I'm saying is that there's going to be a considerable increase in the paperwork having to be done by duty holders. And it's not just, this will be, and people think, oh yeah, more tick box. It may well be more tick box. It depends how the regulator approaches. And again, it comes back to the regulator's resources. But the expectation is it would be more than rather tick box. There will be proactive investigation by the regulator into whether what you're saying is actually true, or in fact you are telling a load of fibs. So it's going to be something you're going to have to watch out for. So as we move to the new regime for higher risk buildings, I have to say that when we talk about risk, we're talking about essentially three areas here: the spread of fire. Now, just on the spread of fire, the draft bill that was published last year just simply said fire. And that was heavily criticized because, but what about gas? What about electricity? All these things are risky, aren't they? And so the government in the bill, the current bill, changed the wording to spread of fire. So that means spread of fire from whatever cause, whether it's gas, whether it's electricity, whatever the cause, it's the spread of fire. Structural failure, well, pretty much I suppose that speaks for itself, and any other prescribed matter. The likelihood, well, the bill does give power to the Secretary of State to introduce regulations to add to the list of safety risks, which he may decide the Secretary of State to introduce gas, electricity, water, possibly into the list. So the other point is that higher risk buildings will now all have to be registered. I have to say, I forget the figure, but I think it was roughly, the government did a survey, roughly about 12,500 higher risk buildings in England. So those will have to be registered. I think there's about, in those high risk buildings, there is approximately 1.3 million residents. If my memory is not terribly brilliant on these things, but I think that's the scale of the work to be done. And then there will have to be an accountable person or principal accountable person. Depends if there's more than one accountable person, but they'll have to decide who's going to be the principal accountable person. Otherwise, there's going to have to be a decision made either by the regulator or the first tier tribunal, which is a property-related tribunal, to decide who is the principal accountable person. But the principal accountable person will have overall responsibility for safety in high-risk buildings, and the principal accountable person will be persons having a legal interest in the common parts of the property, or at least have a repairing covenant in respect to those parts. The regulator's function then in respect of I'm talking about management of safety in high-risk buildings. I'm not talking about design and construction, talking about how these buildings are going to be run and managed following occupation. So the first bit of the mechanics that will be in place will be a building assessment certificate to be issued by the regulator. These certificates will be available to residents to give them the assurance that the accountable person or principal accountable person has taken all reasonable steps to prevent building safety risks materializing, or will be seeking to reduce the severity of any incident. And I have to say they have to report incidents to the regulator. So that would be quite a significant step to give residents assurance. I have to say, talk about residents will also have some responsibility themselves. Their leases or tenancy agreements are likely to be changed. First of all, to give access to their properties if need be, to deal with safety risk. So there will be an impact on residents' own obligations as well as their entitlements. These applications for building assessment certificates, they have to include a copy of what is called the most recent safety case report. I have to say the safety case report, if you look at the HSE website, it will give you some insight into how these safety case reports are to be produced. But it will mean that all those involved in building safety will have had to input to these reports. I mean, including people like, for example, those maintaining lifts will have to input these case reports. And these will be regular reports on the building and safety risks in the building and how they're being managed. And the regulator will need to see these if the regulators are going to say, yes, you're going to get a building assessment certificate that says this building's okay. It's probably not dissimilar to those things. If you go in a restaurant, one of the first things I always look at is the food hygiene rating. And if it's 5, you go in. If it's 1, you avoid it. It'll be like that, but it won't be 1 to 5. You'll either have to get a certificate or not. And if you're not going to get a certificate, the regulator is going to be saying, well, you've got remedial work to be done there. I'm going to have to require that you do this within a certain period of time. So quite effective message that the regulator will have to force work has to be done to be done. And then we've got the golden thread of oh, right, that's all right. We've got finally in the jigsaw, we've got the building safety manager, which is responsible for running the safety on a day-to-day basis. I have to say, when it comes to the safety managers and principal accountable persons, they're like to be existing building management companies anyway, I would have thought. Then the golden thread of information, that is what this is all about, essentially. It will be about providing or having an accessible repository of all data affecting the building's safety, how that's being managed, records of how that's being managed, how that's been addressed. There will be, so anybody providing the information necessary data will have to have suitable building information management systems in place to ensure accuracy and accessibility of information. The bill itself also provides for duty holders to maintain records. There's a lot about sharing of records and information carried through into the regulations, particularly those appointment of persons, industry competence, and duty holders regulations. And there's also be statutory guidance about how you hold information, how you create information. And there'll be prescribed forms that you'll have to fill in, which will make life a bit easier rather than making them up all the time. Then we finally come to the bit that I think is really important, is the implications and challenges of all of this. Well, the architects, when they responded to the bill, they said, well, the bill doesn't do anything about the fact that construction is so fragmented. You know, and I have to say, I've got a bit of sympathy with them. We've got, you know, all these different contracts. I mean, on an average project, you have between 50 and 70 tier 2 contracts. That's a lot. It could be a lot more depending on the size of the project. The average project, 50 to 70. A tier 3, more than that. And of course, these layers of contracting have been driven by the need to effect risk transfer. So the RRBA may have a point, but I'll come back to this second. And then, of course, the government is saying, well, actually, well, no, it's not too bad. I put in the next slide. The government is saying, look, we'll be placing quite major responsibilities on people now to come together, to work together, to manage things together, plan things together, providing each other with information, and, you know, to make sure that the standards of work are maintained and are compliant with regulations. Yes, it is true, but whether they go far enough to meet the RIBA's criticism is another issue. And I'll come back to perhaps that in a second. So then, trying to list what I think could be the major implications and challenges. Well, the scope of the bill, well, of course, most of the interventionist and enforcement powers to the regulator are in relation to high risk buildings. That's been heavily criticized in quite a few quarters and say, you know, that's going to create a two-track system for the industry. We're going to have bits of the industry that are not going to be covered. We're going to have bits that are covered. Why are we going to be? Why are we going to do this? I would counter that, though. I think this is the first stage. I think at the longer term, once we've got this in place, I think there's a strong argument to say, if it's working well, if it's making a difference, yes, let's then spread it right across the whole of construction. I think that would make sense. But let's give this a go and see how it all evolves. But I think you've got to make a start somewhere. I think it'd just be a big task to initially cover the whole of construction with, I say, the quite considerable interventionist powers the regulators will have. The impact upon procurement. I've just seen a chat here from David Freeze. Hackett said that clients should understand and be a lot more critical of what's been done, particularly by duty holders and their roles, which is absolutely right. But on procurement, let me just perhaps make this point. One thing I don't particularly like is that I believe that the legislation simply or continues to perpetuate the design between design and construction. I was on a committee set up by the HSE before 2007 to draft the 2007 CDM regulations. And one of the arguments I put forward there, can we get an idea from this principal designer, principal contractor, designers, contractors idea? Let's move forward. Let's if we want to generate a much more holistic approach to the way that we resolve solutions to how we deliver projects, we should be talking about much more about proactive project management. We should be talking about delivery teams. And my hope is that the regulator, once the regulator is able to see what it is emerging in terms of this available advice that I was talking about earlier, that procurement approaches like alliancing that do make for collaboration, because in fact they do force people to work together on a no-blame basis to work through solutions. These are the most desirable type of approaches to procurement. So we have to see what emerges. On competence, I think it's a good start. I like the behaviours thing coming into the legislation. I still believe, however, and I hope this competence committee that the regulator will be dealing with and set up to support the regulator will be looking at in the longer term, a statutory licensing system. I mean, you've got it in a lot of American states. You can't work in construction or in design unless you are licensed. And license means having proven capability on safety, capability in regard to standards and technical standards and so on. And they have it in some Australian states and even some European states. So we need to look at this in the longer term. Charles might be a bit more familiar with the Australian system than me. And then finally, as we deal with the challenges, the gateway system, obviously, particularly Gateway 2 and Gateway 3 were referred to, this could obviously impact upon project costs, could delay things. If the regulator says, sorry, we're not going to go into Gateway 3, I'm not satisfied that we reached Gateway 2 yet, things have got to be done here. The implications on the delivery team in relation to the costs associated with the gateway system, and actually who pays for that, my gut feeling always is, well, the people who pay at the end of the day would be those at the end of the supply chain. So that would be could be a cause of some anxiety. There will then, I say, be the next bullet there. We'll have to get used, as I mentioned, providing a lot more information, probably and hopefully in prescribed form, but a lot more information on what we're doing to address particularly safety risk and how we dealt with standards, with building regulations in the work we're doing. So it's a whole new regime. And finally, there's been quite a bit of chat around about PI cover. We all know at the moment PI cover is extremely expensive, assuming you can get it now. A lot of insurers have left the market, so capacity in the market is far tighter. Some companies reported premiums going up as high as 700%. So the question really is, what appetite is there in the insurance market for, particularly for insuring duty holders and principal designers, principal contractors in respect of their own duties, given the fact, of course, they could be ended up, if they do things wrongly or even negligently, possibly facing fines and at worst imprisonment. So something to think about. I'd be interested in thoughts amongst the audience about these various things. Thank you so much, Amanda. And thank you, Charles.
Thank you. Thank you very much, Rudi, for a terrific run through of an enormous topic.
I'm sorry I went over a bit.
You have to beg forgiveness from your attendees. There have been, if I can get up the chat and see if we've got some questions here. We've got something here from Richard Bayfield. He has shared that the IC risk group published the In Plain Sight report, and he's very helpfully given the link for that. Principally, I'm paraphrasing now, Richard, I hope that's okay, around the issues of competence and the need for training. That seems to be a very important part of this bill. It's the mentioning of behaviours and the competency requirements and the encouragement and support of people, or the expectation that people will say, I can't do this, I'm not up to scratch to do it. Implied in that is support for whistleblowing, effectively. And then from Chris Blythe, he says it is likely that the cost of occupying an apartment, as in the service charge, will increase dramatically with these new obligations put in place. So what do you think about that? Rudi, do you expect the costs to be passed down to the end consumer, whether that's a leaseholder or the purchaser of properties or corporate tenancies?
Yeah, I think Chris is absolutely right. What has caused one of the bigger controversies around this bill is the introduction of a building service charge, which will have to be put into leases. At the moment, leases will have obviously service charges in regard to the maintenance of common parts, but the bill now requires this building safety charge now to be put into leases. That could add, who knows, another £50. It depends what, obviously, it's hard to say, but maybe another £50, £100 extra on your service charges per month, but there have to be a separate identifiable building safety charge in your lease. Chris is absolutely right. There's likely to be, depending on the nature of the building, a fairly hefty, or could be a hefty increase in charges with this new building safety charge. Amanda, do you mind if I just one thing? I just saw something from David Fries there, which is a really good question. Do you mind if I just come to that? Yeah. David says, I got the point wrong because I just saw a bit coming up early on my screen. Hackett said that clients should understand and critically feel their responsibilities. Does the bill meet that test? Clients should understand and critically feel their responsibilities. David, it's a brilliant question, and it's almost one, because it's so good, impossible to answer. The fact is that the reading through the bill myself and the supporting regulations that are published to date, what I would say is that clients have got to be more proactive, and what I was pleased about was the fact they've got to be particularly more proactive in relation to competence, and that proactiveness or proactivity increases when it comes to higher risk buildings as well, particularly with the gateway system. So I think the gateway system is going to have a bigger impact than is currently the situation upon clients and developers. Whether that then, with the situation with regard to construction more generally, I say difficult question to answer, or we can say we hope. But I just think overall the competence requirements may well force far greater activity, and I hope they will, with regard to clients, indeed anybody appointing other duty holders, that they will have to take on board a lot more oversight of competence of those that are delivering their jobs. And also, I think there will be the opportunity, if this isn't happening, even across the whole of construction, the regulator's now there. There's an opportunity here to bring these facts and matters to the regulator. Not the regulator, but be able to do a lot for the wider construction process, but will be able to see what's going on and possibly even intervene if the matter is serious.
Thank you, Rudi. There's a follow-on from David Fries on the matter of gateways. So he says, do the gateways signal the end of build and design? Does the building have to be designed before construction starts? Also, does this make value engineering, as it currently operates, more difficult?
Well, on the latter bit, firstly, it'll make value engineering more difficult if, of course, and we all know what value engineering means. Anybody watching this will know what it means, I think, which is actually about cutting corners, which is one day Dame Judith Hackett came out against. But certainly if in cutting corners in order to reduce the price, you are compromising on safety, I think there certainly is going to be much more care, hopefully, in the way we go about value engineering. The other point about design and build, no, the situation, gateway situation, doesn't change that, because in fact the contractor is a designer as well as a, well, I say a contractor, I mean, as we know, most of the construction we've let to supply chain, but as a designer, the design and build contractor will also have to partake and make sure that it satisfies the Gateway 2 requirements. I emphasize the Gateway 2 requirements we don't know in detail yet. We've got to wait a few weeks for these new regulations to come out.
Okay, thank you. And before I just check it with everybody online, I am aware that we're slightly over time. Talk to Rudi about that. And there's a question here from Chris Blythe. Do you think the polluter pays amendments being discussed at the moment will bring real relief to leaseholders?
I haven't looked at that in any detail, Chris, so I couldn't really answer that. So if I try and guess a response, it wouldn't really be appropriate, unless anybody else on this call will know. Okay,
anybody wants to sort of put their hand up and actually put their voice into the room? John. You're on mute, John. You're on mute, John. No, you have to press your unmute button.
Can you hear me now?
Yes.
Thank you. Sorry about that. Rudi, as ever, superb review. Thank you very much. I've done a little reading on the subject matter, and it looks pretty complex, and you did a fantastic job introducing the various ingredients there. The one thing I would just, perhaps unsurprisingly, I'd like just to pick up, Rudi, is your point about behavior. And we have always had, do have, and will continue to have the irony of both humanistic and corporate attitude to risk. Inherently, as individuals, we actually, ironically, appreciate, we want certainty, and yet we enjoy risk. We enjoy the uncertainty of the outcome of a sporting event. Some people would want to go mountaineering, knowing that there's risk, but nonetheless wanting to put themselves in a risky situation. And throughout life, I would emphasize both personally and corporately, even the very fact of businesses going into business, they don't go into business knowing what the outcome will be. They're willing to take risk. So I'll shut up really, but just to respect the importance, I think, of managing behavior, but in a realistic way, and how, as part of this progression of this safety bill, and what the act will follow, how we might build in training or recognition of the tension within us individually and corporately on this subject.
John, I think that's a very valuable comment you've made, and thank you for your earlier remarks there. Yeah, I think I highlighted the behaviours point because, you know, if you want to look at the way that behaviours is defined, it would be certainly useful to go to the regulations I referred to. But of course, there's risk and risk and risk, isn't there? And now, when it comes to building safety, we simply cannot afford to take our chances. I think that's certainly the key message coming out of this legislation, and will keep coming out as more and more regulations are introduced. What will be interesting, I mean, going back to the point that Richard was making earlier, Richard Bayfield, about training, what it will mean, I think, John, is that organisations will, when it comes to training their staff around this new regime, will certainly have to focus a lot on behaviors of each individual involved. And that's going to be, perhaps for a lot of organizations, quite different from what they do at the moment. Yeah. So having appreciation of that, I think, is going to be important for most businesses. Certainly, if you're going to get caught in this in work that's going to be caught by these regulations. But I do like, I must admit, I do like the fact that in a piece of legislation, and I can't recall ever seeing it before, and I've looked at lots of legislation in my lifetime, I can't ever remember this word behaviors coming through in a piece of legislation. In guidance, yes, stuff like that, but not in primary legislation.
Thank you.
Regulation.
I think one thing that comes to mind, Charles, I'll come to you in a second. One thing that comes to mind is the importance of the connection between the requirements for competence, and you talk about licensing further down the line, and hopefully sooner rather than later. But that competence and the behaviours being part of the assessment of that competence. And somehow that connects to the PI insurance in some way. And I just wondered if anybody is in our group would like to argue with me or pick that up and elaborate.
I know Graham's in the audience.
I know, but I'm trying.
He's probably on, I think he's on mute.
He's on mute. I don't
know.
I mean, I could talk for longer than Rudi. You don't want to be going on till 4 o'clock. I mean, just an observation I would make, and a question on the point about risk. Yeah, we know that there's risk in all walks of life. But we try and mitigate and transfer it where possible. One of the problems that the construction industry has is that most people want to dump risk. The problem is that the mechanisms that underpin that risk dumping don't work. One of the problems, the main reasons that the insurance products available at the moment are costly and inadequate is that the insurance industry has reacted in, I think, the wrong way. The insurance industry has reacted to a very poorly run, poorly procured construction industry purely by ramping up costs, ramping up rates, many insurers running away from the market without actually looking at the root causes of the problems that the insurers have incurred. Rather than reacting to a flawed procurement model approach, the insurance industry should be, they're potentially in a very strong position to dictate to the industry how it procures its business. The problem is that everybody relies on lawyers and funders, and with the greatest respect to any lawyers apart from Rudi, who might be in the audience, they like a bust up. Funders, unfortunately, just follow lawyers. They're tick box merchants. They don't understand risk transfer, and we need a fundamental reappraisal of the way in which construction is procured in primary legislation. That's so important. Behaviour. Part of the problem with the likes of professional indemnity insurance is that it just embellishes poor behaviour, silo mentality. You know, we're talking about BIM. I mean, PI insurers don't like BIM because it's sharing of information. I mean, you know, we need a fundamental change. My approach, my view is that we need to develop new insurance products for genuinely collaborative procurement models. I'll say no more because I could go on for hours.
Well, thank you very much. And on the back
Amanda, do you mind if I just pick up just one? Well, it's not picking up what Graham said. It's the fact that observing that, obviously, as Graham said, the flawed procurement models actually create their own risk anyway. But I think one thing about insurance is that the degree of information and material that's now going to have to be provided in this new regime will give insurers a lot more insight into what is going on. And that may well be helpful, particularly in respect of premium setting. So there is a bit of an upside, but I do agree with pretty much everything that Graham is saying.
Can I just comment on that? Insurers are quite adept at using digital technology in looking at how they assess premiums, claims management, all the rest of it. The problem is they've shown absolutely no interest whatsoever in how digital technology combined with good procurement can improve their risk. That's something they've got to look at very closely.
Charles, you wanted to say something. I've got something from Ruth here that's on the back of that. Will your question change the tack, or? Yes,
it will.
So Rudi. May I address Ruth and then come back to you? I haven't forgotten you. Ruth says, thinking back to my first client role with no training but a lot of common sense and health and safety awareness, and the limits of my authority on several matters, not just safety, I would have been horrified to discover such responsibilities, particularly if I feared that others with input into the project were professionals but may lack the knowledge or focus. However, I would have been lucky that my senior managers would have backed me to put it right. What is the liability of commissioning organisations to support their employees through training, drawing some tough lines, etc.? That's speaking to competence and the dire responsibilities that will be on the duty holders and the authorised person responsible.
Organisations obviously will have responsibilities under this legislation if they are duty holders, and if they haven't trained or they fail to train their people sufficiently, that brings about their possible liability under this regime. Then they're going to have to face that. And particularly in respect of high risk buildings, I mean, that liability, as I say, could well lead to fines and ultimately imprisonment, although it won't be imprisonment of organisations, fines, although individual duty holders, of course, could face that penalty. But I would think what that will mean is that organisations are not necessarily going to say, well, are we now doing a high-risk building or are we doing another sort of building? I think they will want to bring together the demands of this new regime and do that in their approach to training their staff, their employees, but not just their staff and employees, because as we know, there's a lot of subcontracting. So they will have to make sure that where they subcontract their work, that subcontracting then, or those subcontractors also are up to speed. Okay. So it's be quite a responsibility.
Thank you. Charles, thank you for your patience in waiting to make your contribution.
Okay, Amanda, that's fine. Rudi, you mentioned that I might be able to reflect on the Australian situation. And what I can tell you is that what's happened in Australia in recent years highlights the need for this legislation very much. I'll just give you some background. Going back, or perhaps 20 years ago, there was quite a big swing towards self-assessment of quality standards in high-risk buildings, or in all buildings, whereby the developers and contractors were responsible for lining up the assessors and managing them, and just putting in a report in at the end of the day saying everything was in compliance. Well, unfortunately, this hasn't worked out so well because I guess very much a minority of cases, but you've had what I might call, for want of a better term, captive assessors. And there's been some very poor quality high-rise residential in particular in Melbourne and Sydney, and they're having some major problems. And in the last 12 months, because of this, they're swinging around to what the sort of controls that this bill has in it. They're changing tack quite considerably and having to tighten up a lot because of this very poor self-assessment regime.
That's helpful, Charles. I just going back perhaps a little on. I mean, back to this issue of risk, though. One of the things I've been working on with other people like Steve Woodward, I think is on the call, and Anton Krause and others at Resolix is a digital smart risk register to enable the use of machine learning and artificial intelligence to be able to manage risk more effectively. It's a point that Graham made, I think, about digitization of the risk process. There's a very good article if you want to read. I had to say it's very good because I was one of the authors, but there are others like Stephen. There's an excellent article in the May 2020 issue of Construction Law Journal. So if you want to read about the Smart Risk Register, that would be quite useful. This is, I say, I mean, we've got these tools, we've got machine learning, we've got AI now. We could use this to, in a much more productive way, to help us not just identify risk ownership, but able to manage it and even predict it. So something I think we certainly need to look at, and maybe something like this will help us get some funding to move this forward.
There is just one question. I'm not sure. Anton Krause, are you still on the call? Anton, are you there? Let's have a look. No, he's got.
Anton's still with us.
Is he? Hmm. Can you put your hand up, Anton?
Can't see a photo. He's still showing to be with us.
Okay. Well, I can't see him, I'm afraid. Because he had a question that, or a contribution to make about how important it is now with this particular regime that there is some kind of push to have a repository of data. And one of the things you raised, Rudi, is that people have been very, very reluctant to share data, and I'm not sure, because I haven't read through the entirety of the bill, whether there's enough push here to make people, share the appropriate data. And maybe that's the regulator's job, is to pull the data from people, and not providing that data is non-compliance. Yeah. And there's a whole masterclass, I'm sure, on how we could go about that and the value of blockchain, etc. But I am hearing quite a few people dropping off the call, and that's usually a signal that we have outstayed our welcome. And so not wanting to prolong that anymore, it has been my privilege to host this, and I know that my colleagues too. Firstly, Rudi, thank you for extraordinary hard work, intellect and goodwill that was packaged so beautifully in your presentation today. Our grateful thanks for that. And a really warm thank you to all of you who attended today. If you have further questions, please send them to us, info@cigservices.co.uk. I do have a couple of polls, but I'm not sure. And we'll send those out by email. There are two things that we want to know, whether we're any good, if you enjoyed it or not, of course. And the other question that I had was, were you able to connect via the link in your booking email? And did any of you have any difficulties? Because on past masterclasses, a few people have had trouble clicking the link and getting it. So those are my two questions. If any of you are inclined to answer, put something in the chat for me. We will send out an email again, with when the video is available and Rudi's presentation. And also we've got 3 topics that we think might be interesting for you as masterclasses. There's the PFI expiry and handback. Is that something that you'd like to hear again with updates if you weren't able to attend before? The second question is any topic which would be sort of on bidding or the supply chain or any of that nature. And one which is something that's quite interesting for me. Are any of you interested in a masterclass on dispute resolution? I ask that because we've got the question in the air of mandatory mediation in some sectors. And I think there's kind of an appetite to look at what that means, and certainly against the potential for disputes. And perhaps it even touches on the issues around insurance. So Graham's answered that for me. So if any of you have any thoughts on that, please let us know by replying to any of the emails that you've got from us. What would you like to hear next? We've got some ideas, but we'd like to know what you would like. And on that note, unless anybody has anything
Well, I'd like to thank you, Rudi, very much, and Amanda for hosting it. Excellent masterclass. Thank you.
You're very kind. Thank you. Well, it's a great privilege, Rudi. You know, he was a star player.
Thank you, Rudi. Thanks, Amanda. Fantastic. Really enjoyed it.
I bid you a good afternoon and see you next time.
Thank you.
Bye,
Thank you, Amanda. Thank you, Rudi.
Cheers, Rudi. Thanks, Rudi.
Well done.
Bye, Chris.
Bye, Chris.
Bye-bye.
Thank you. Bye-bye. Bye, Rudi.
Bye, Rudi.
Bye, Michelle.
Michelle.
Bye. Bye-bye. Bye-bye. Thank you.